Owners face the grim prospect of owing huge sums of money to municipalities in debt incurred by the previous owners, dating back up to 30 years. Now, that is shocking news. Why? This emerged following the judgment handed down by the Supreme Court of Appeal at the end of last month, which ruled that new property owners can be held liable for historic debts dating back 3 decades. Now, this is based on the Supreme Court of Appeal case involving a matter between the city of Tshwane and Peregrine Joseph Mitchell, who purchased a property in Tshwane in 2013. Now, he was told he had to pay over 200,000 rand for a clearance certificate, but he claimed that in terms of Section 118, he was liable to pay just above 100,000 rand for the debt due for the previous 2 years. Now, what that means is that all the other debt was basically written off. Now, to take us through the case, we are joined in studio by Priscilla Majeng-Maesela. She is a notary and a conveyancer at Molefe-Dlepu Attorneys and Conveyancers. Priscilla, a very good morning to you and welcome.
Morning to you too, Elvis, and good morning to the viewers.
First and foremostly, take us through the case. Was this judgment, by the way, passed on a bill or a law as it stands?
It's not a bill, because a bill is a draft of a law that might be passed. So in this case, it's actually the law, the current law under the Local Municipal Systems Act, which states under Section 118 that the first subsection actually states that before the registrar of deeds can transfer property to the purchaser, then the seller must be issued with a clearance certificate confirming that all the rates and taxes for the previous 2 years have been paid.
Only 2 years?
Only 2 years, but then that's what Section 118 subsection 1 says. But then Section 118 subsection 3, it basically says the same thing, but then it goes on further to say that the municipality, they actually have preference over the banks. Yes, in that regard.
So what it means in this particular case, this gentleman paid really what was due in terms of subsection 118,
yes.
but in terms of 3, he did not comply.
No, he did not, because there was still that historic debt that still remained, that he actually still owed, that he incurred from the previous owners. Yes.
So that means the new owner is liable for historic debt which was not incurred by him or her.
Yes, well, the section says that if the municipality wishes, they can actually enforce that. They can actually request that the current owner or the present owner of the property pay the historic debts of the other previous owners. Yes,
But what sort of recourse does the current owner now have in terms of this historic debt that he receives?
Honestly, because of the current case, there's really not much that they can do. Yes.
Okay. Now, looking at the details of this case, should you say that any property, that if you want to buy property, that you need to check that all the historic debt is being settled by the previous owner, or what can you do to ensure that?
I think that would actually be wise. Actually, estate agents and attorneys, we should make thorough investigations to ensure that the present debt and the historic debts have been paid. And another thing is that they must ensure that the purchaser, before transfer passes to the seller before transfer passes to the new purchaser, must actually provide proof that he actually has paid all the money that is due to the municipality. There should actually be a provision in the deed of sale that actually says that before transfer can take place, it must make provision for all of that, for the purchaser, for the seller to pay all the monies and to make sure and to provide proof. And then the purchaser and then the current owner will in a way have recourse to claim damages against the previous owner should later on the municipality come and now claim historic debts.
Would that then be written into the offer to purchase?
Yes, it should be written, clearly stated into the offer.
Now, just briefly, does this have an impact on people with leasehold or people that rent or not?
It has an impact on everyone, actually, yes. It applies to everyone. It actually doesn't matter whether you acquired the property by way of a sale, in execution, as was the case in the Mitchell in the JP Mitchell case. It just applies. It doesn't matter in what fashion you acquired the property.
Priscilla, thank you so much for making that clear for us.
Oh, thank you.
That was Priscilla Majeng-Maesela. Now, she is a notary and conveyancer at Molefe-Dlepu Attorneys and Conveyancers. And remember that we will discuss this because this is part of a theme today that we're taking this story and we really unpack all the issues for you. So this is a starting point. Stay tuned here.